So picture this. It's 1993, and a series of newspaper ads suddenly kicks up this massive legal storm in the Philippines. It actually forced the Supreme Court to step in and answer a really fundamental question. What does it truly mean to practice law? And where do you draw the line when it comes to advertising legal services? Well, that's the story of Ulep versus the Legal Clinic Incorporated. It all began with ads just like this one. Secret marriage for a flat fee of 560 pesos. I mean, it was incredibly bold, super direct, and it offered services that made a lot of people in the legal world do a double take. This wasn't your typical lawyer's shingle. This was a straight-up commercial approach to legal matters, and that was just not something you saw back then. And believe it or not, they didn't stop there. They pushed the envelope even further with an ad for Guam divorce, which even featured a foreign attorney and offered free books. Now, this was a whole different level. We're not just talking about local issues anymore. This ad waded right into the really complex and sensitive topics of foreign divorce and immigration, which, as you can imagine, raised even more red flags. Okay, so to really get our heads around this landmark case, we're going to break it down just like a formal legal digest. We're going to walk through the facts, pinpoint the core legal issues the court had to tackle, look at the definitive ruling, understand the court's reasoning, explore the key ethical principles that came into play, and finally, see what orders the court handed down. So let's start with the facts. The whole thing was kicked off by Mauricio C. Ulep, a lawyer who saw these ads and just felt they were, frankly, offensive and degrading to the entire legal profession. So he took action and filed a petition directly with the Supreme Court to get the Legal Clinic Inc. to stop publishing them. And right here, this is the heart of the conflict. You've got two completely different sides. Petitioner Ulep argued that these ads were champtress, basically stirring up litigation for profit, unethical, and just plain demeaning. But on the other side, the legal clinic came back and said, hold on, we're not actually practicing law. We're just providing legal support services, and those should be advertisable. You know, the Supreme Court saw just how significant this was. They didn't decide this in a vacuum. They actually required 6 of the country's major bar associations to submit their official positions on the matter. That tells you everything you need to know. This wasn't just about one controversial clinic. This was about the integrity and the very future of the entire legal profession in the Philippines. So all of this brought the court to the core legal issues. It had to settle some fundamental questions that would really define the boundaries of what it means to practice law in the country for decades to come. It boiled down to 2 critical questions. First, do the services offered by the legal clinic, even what they called legal support, actually count as the practice of law? And second, whatever the answer to that is, can you advertise these services to the public in such a commercial way? All right, so after weighing all the arguments from both sides and considering the opinions from all those bar associations, the Supreme Court came back with a really clear and definitive ruling on both of those major issues. On that first issue, the court's answer was an unambiguous yes. The activities of the Legal Clinic Inc. absolutely constitute the practice of law. That whole attempt to distinguish between legal services and legal support services, the court saw it as a distinction without a difference. It just didn't hold up. And because the court found they were practicing law, it logically followed that their newspaper ads were, in fact, unethical. They were a clear violation of the Code of Professional Responsibility, which has very strict rules about how lawyers can and cannot advertise their services. But how did the court arrive at that conclusion? This is where we get into the ratio decidendi, the legal reasoning behind the decision. To understand the ruling, you first have to understand how the court defined the practice of law. Well, the court affirmed a very, very broad definition. They made it clear that the practice of law isn't just about showing up in a courtroom. No, it's any activity, whether it's in or out of court, that requires you to apply legal knowledge, legal procedures, training, and experience. And the court even broke it down into practical examples. Things like giving legal advice, drafting legal documents, giving an opinion on what a law means, or even just advising a client about their legal rights. All of these things fall squarely under that big umbrella of practicing law. And here we have it, the absolute key to the court's reasoning. The essence of legal practice isn't just putting general information out there, like in a textbook. It's about that personal connection, representing and advising a specific person dealing with their own unique situation. And this is exactly why the legal clinic's main defense just fell apart. They claimed their services were non-advisory. But the court basically said, look, there is no way you can explain something as complicated as foreign divorce law to a client with a specific problem without giving them legal advice. Applying the law to a person's individual circumstances is the practice of law, period. So, since the court established that the legal clinic was practicing law, it had to turn to the second question, the ethics of their advertising. And this led the court to strongly reaffirm one of the most foundational principles of the entire legal profession. The court drew a very firm line in the sand. They reiterated that law is a profession, not just a business or a trade. A lawyer simply cannot advertise their skills the way a merchant advertises products. And why is that? Because for a lawyer, the absolute best advertisement is a solid, well-earned reputation for being competent and trustworthy. Actively soliciting cases for money isn't just bad form, it's malpractice. Now, that doesn't mean lawyers have to be completely invisible. The court was clear about what is allowed. We're talking about dignified, professional announcements. Things like a brief bio in a respected law directory, a simple professional card, or maybe a small notice that you've opened a new office. It's a world away from the flashy ads the legal clinic was running. And the court drove home a crucial point about why these rules exist. It's not about being anti-competitive or protecting lawyers from each other. The primary goal here is to protect the public, to shield people from incompetent, unreliable, or flat-out dishonest individuals who might try to pass themselves off as legal experts. So, having laid out its clear ruling and all the reasoning behind it, the Supreme Court then issued a set of specific orders to wrap up the case. This final part is what's known as the disposition. The court's orders came in 3 parts. First, it permanently banned the legal clinic from publishing those ads or anything like them ever again. Second, it issued an official reprimand to the clinic's founder, attorney Rogelio Nogales, along with a stern warning. And third, it passed the case over to the Solicitor General to investigate a bigger question. Can a corporation even be legally set up to practice law in the first place? So what are the big doctrines we can take away from this case? First, the definition of practice of law is incredibly broad. It's way more than just going to court. Second, in the Philippines, you can't form a corporation for the purpose of practicing law. And third, those very strict limits on advertising are there for a vital reason, to protect the public and uphold the dignity of the profession. And that leaves us with a really fascinating question for our modern world. Remember, this case was decided in 1993, long before the internet, social media, and all these legal tech startups changed the game. So the question for us today is, how do we take these timeless, foundational principles and apply them now? How do we strike that balance between protecting the public and still making room for innovation?